the appellants afresh. The facts relevant for the present purpose lie in a narrow compass. In respect of an incident dated 14th April 90, various persons were charged for offences under 302-149 of the IPC and other offences. The appellants in this appeal were not made accused. They were, however, summoned under 319 of the Code of Criminal Procedure and were arraigned as accused after the entire evidence has been recorded and also after statement of accused under 313 had been recorded. Arguments were heard and judgment was reserved. Not only that, after the appellants were summoned under 319, the prosecution did not examine again all prosecution witnesses. Out of 16 witnesses, 6 were examined and police papers were also not supplied to them. The appellant and 4 others were, however, convicted for offences under 302-149 and other offences, and rigorous imprisonment for life, besides fine of 10,000 was imposed in terms of the judgment and order of the Court of Session dated 29th June. Insofar as the 2 appellants are concerned, the High Court, by the impugned judgment, after noticing the aforesaid facts, coming to the conclusion that serious prejudice has been caused to them, setting aside the conviction and sentence, insofar they were concerned, directed their retrial. The High Court, it seems, considered that at such distance point of time, many witnesses may not be available, directed that all witnesses examined earlier, if available, shall be re-examined after police papers are supplied to the appellant. As noticed earlier, incident relates to the year 1990. 4 accused have been convicted. Their conviction has attained finality. Section 319 has been construed by this court in Michael Machado and Sashikant. Applying the ratio of these decisions on the facts of the aforesaid applicants could not have been directed to be retried. Under these circumstances, we set aside the impugned judgment of the High Court to the extent it directs retrial of the appellant and uphold it to the extent it sets aside the conviction, sets aside the judgment and order convicting the appellant. So here what happened? 319 was moved apparently after everything was done and judgment had been reserved. But they were summoned and then the trial was opened again. As my lord was mentioning that if judgment is reserved and an application comes, then what happens? Trial is opened again. Out of the 16, 6 are examined in that very trial. And police papers were not supplied, etc., which was vitiated the trial. And your lordship said you can't do it again now. So it has to be done properly along with the other co-accused. Now, my lord, if your lordship will see the reference order, I'll just take your lordship to that and then make my submissions. Your lordship will have para 9. Before I read that, my lord had said that how is the High Court dealt with it. Shall I just show your lordship that this part of the High Court's finding? The High Court actually, this argument in the main paper book, if your lordship will have, this argument is at page 15, starts at 15. High Court only relies on Shashikant and prefers Shashikant over her. Kindly have page 15. Page 15, the next submission, lower half of the page. The next submission of the learned senior counsel for the petitioners is that the trial court became functus officio on the date of the judgment, that is 31st October. In that connection, they cited paragraphs 37 to 39 from the Constitution Bench judgment in Hardeep Singh. They relied on para so-and-so, then other judgments also. Then from 16 onwards, the High Court quotes the order passed by the trial court. Sorry, it quotes Shashikant. Sorry, quotes Shashikant, and then, my lord, page 21, it says the decision in the case of Shashikant, page 21 in the middle. The decision in the case of Shashikant was not cited before the Constitution Bench in Hardeep Singh. To my mind, the decision in case of Shashikant is directly on the point involved as against the decision in Hardeep Singh. And therefore, in terms of the decision of Shashikant, the submission will have to be repelled, which I hereby do. So the contention is rejected relying on Shashikant, saying it is covered by Shashikant. Even otherwise, para 39 of Hardeep Singh would throw light. And it says to say that powers under 319 can be exercised only during trial would be reducing the impact of the word inquiry. It is settled principle of law that an interpretation will lead to. So this, he says, this the court was saying, it can be done during inquiry or trial. Now he's reading this to mean that because the court says it can only be done during trial, can be exercised only during trial, he's reading to say it can be done after trial also. Completely misreading it. And then para 22, page 22, he says, apart from that, a coordinate bench in Amarnath held that power under 319 can be exercised even after the judgment is concluded. In that case, the accused were acquitted by the trial court. After 4 months, the trial court exercised the power for summoning the accused. This court relied upon the judgment of Shashikant for that purpose. Present case stands on a better footing. Order was passed simultaneously, and the contention is thus rejected. Now, out of the judgment which I have cited and not read of the High Courts, there is a judgment of the Delhi High Court and Jharkhand High Court where it was exercised on the same day, like us. Both those High Courts have gone into the provisions of the code and said it cannot be done after judgment is pronounced, even if it is being done on the same day. So this is how the High Court deals with it. Now, Your Lordship may just come to the reference order. I have actually made a written submission on all three questions. So that I've given to Your Lordships, I'll just quickly glance over, take Your Lordships quickly over it, not too much. I've already argued most of it. So therefore, that's my answer. But just kindly see para 17. The High Court has placed extensive reliance on the factual metrics. Sorry, the Lordship has a reference order. Para 17. The High Court has placed extensive reliance on the factual metrics of Shashikant's case to draw parallels between the similarities in both cases. The summoning order in the former case was passed before the trial had ended, whereas in this case it is passed after the trial, that is after passing of judgment in session case 289. Therefore, this court, while dealing with Shashikant, interpreted the law based on the facts available therein, whereas the present case has a different context altogether. So even in the reference, Your Lordships have drawn that distinction. And then according to me, said that Shashikant, in this context, it is important to note that Hardeep Singh was first heard by two judge bench, etc. Then Your Lordship may come to the questions, my Lord, which are there. At page 15, para 27, those three questions are framed. First question is whether the trial court has the power under section 319 of the CRPC for summoning additional accused when the trial with respect to other co-accused has ended and on the judgment of conviction rendered before pronouncing the summoning order. But I have already addressed Your Lordships on that. Therefore, I have nothing more to say on that, apart from what I have said. 2, whether the trial court has power under section 319 of the CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing or pending, having been bifurcated from the main trial. Now, the only provision to bifurcate is 3172. In my case, this situation does not arise. We cannot use absconding accused loosely here. The question is whether when the trial is bifurcated,
split.
Yes, when trial in respect of certain other accused is bifurcated, Now, trial will start after they are charged. When charge is framed, trial starts. I can even imagine the section 317 says even at the stage of inquiry. So at the very least, a charge sheet under 173 should have been filed against them. In my case, there is no such accused against whom who was absconding and whose charge sheet had been filed. There was one accused who was absconding, but in his case, investigation was continued. Investigation continued right up to 2019, when ultimately a charge sheet is filed in his case. He is arrested, charge sheet is filed, and that is registered as a separate session trial where not a single PW has been examined so far. Charge has been framed against him in that trial. Not a single PW has been examined. So therefore, my lord, I say in the facts of my case, actually this question does not arise at all, is my first point. My second point is this question will have to be answered in the light of a fact situation. Your lordships in the abstract cannot answer it. In abstract, if their trial is actually split up for some accused and the same trial in which 319 was filed remains pending, then perhaps something can be said that 319 could continue. But that has to be answered in each fact situation. In my fact situation, the fact that no trial remained pending is also clear from the order made in the 319 application. No trial, therefore he had to register it as a miscellaneous application.
But there is also a direction that in the case the absconding surrenders or is produced by the police, case be reopened.
No, he says file is consigned to record, attach this file. Attach this file. Like if a decided case, your lordship calls for so many decided cases when your lordship is dealing with another matter. Therefore, I read that order and I'm very glad, obliged for this observation. Therefore, there is a material difference between saying file be consigned to the records and file be consigned to the records as and when that man is caught, this file can be attached. And in that case, perhaps the file was attached, but that's a separate case. Now, kindly see the distinction between this and 3172. There is a major, so many times when your lordship decides and finishes a case, your lordship calls for the records. It may be relevant, not what that witness had said, because the same persons will come into depose. In that trial also, there is a material difference between 3172 and what has happened here. 317, kindly have 3172. If the accused 3172 in any such case is not represented by a pleader, or if the judge or magistrate considers his personal attendance necessary, he may, if he thinks fit and for reasons to be recorded by him, either adjourn such inquiry or trial, or order that the case of the accused be taken up or tried separately. So it's an inquiry or trial which can be separated. And my lord, in any case, in the facts of this case, that 31st October is of no legal consequence because factually that trial has never continued. That accused is now facing a fresh trial of 2019. So therefore, according to me, that order of 31st October will be of no legal consequence at all. Now, on the third question, my lord, what are the guidelines that the competent court must follow while exercising power under 319? Now, these guidelines are given in Hardeep's. They are elaborately dealt with. That what is the nature of evidence when it. So I wonder if your lordship would want to reopen. I am not asking your lordships to reopen that part of it, my lord, unless the other side says that something in Hardeep is wrongly decided, etc.
My contention is this: the subsequent order, the third question is not there. Three judges bench order on September order. The third question is not.
So therefore, we are all one.
The third question is really. Finally, have a look at the order.
Correct.
Ordered at 5th September.
The solicitor is right.
Further investigation in light of the circumstances occurring in this case.
5th September is not.
That was possibly for reference to the three judges bench.
No, it was an extract, Mr. Solicitor. Actually, that was only an extract. It is
Correct.
not fully extracted.
Correct.
Paragraph 26 and 27 of the order dated 10/5/2019 are not fully extracted. That's all. Just see the.
Yes.
We can't really say that it is an extract.
No, because, no, what is before is the last paragraph.
There are-
Correct.
Having considered the matter at length.
Yes.
And consider the matter at length, we are of views of opinion expressed in our duty. Consider the views of other organizations occurring in this case in business. But that's interesting. Two questions. The lordship would have extracted all the three questions. The back-
Lord, may I? Probably, my lord, the third is apparently for the above two. Guidelines for above two. 1 and 2 is the reference, and number 3 is guidelines for the above two. Probably it seems to be, my lord, the reference for that.
Correct. Guidelines under 319.
Yes, for the my lord, first two questions which are
But in
answered.
my respectful submission, Hardeep Singh gives sufficient guidelines.
So it is in
under 319.
continuation of first and second that the guidelines are to be laid down. This is probably, my lord, the reference.
No.
Because the Hardeep
What are
Singh
the
case,
guidelines and the components?
No, no,
What
it is
follow?
not.
So it's-
Lord,
Yeah,
it's
it's
not-
first and
not-
second, my lord, if first
It
and
is not restricted to that.
It's not
if
restricted.
first and second are read, my lord, probably because Hardeep Singh has laid down the entire.
What is that here? What are the guidelines that the
Competent court must follow it.
while exercising power?
But if it is to be read in continuity, my lord, it seems to be that. Of course, it is the prerogative of the
I am
honorable
reading all
bench.
the three questions.
But-
I have only
But then
suggested third
it seems to be in
question.
continuation.
Is the third question really necessary? Because
It is not, my lord, probably. It is covered, my lord, it is covered.
Yes, it is inherent in the.
That is probably why it is not extracted.
Only a-
from order.
There may be something, my lord, which I may just request may be added, my lord, in Hardeep Singh's case. Otherwise, it entirely, my lord, covers everything. Hardeep Singh is a.
So, my lord, so far as my submission is concerned, my lord, what is the nature of evidence? Yes,
Please conclude, I think you have concluded.
I have concluded.
We will hear the others.
Yes, yes, absolutely. So third question, my lord, I have made a written submission. I'm only saying it's already covered by what Hardeep Singh says. My lord. I will only conclude by saying, my lord, that there is no
As Sister said, the answer to question number 1 will be the guideline because that will be the law declared.
Correct, correct, correct. And 2 also actually is different fact situation. And my fact situation, there is no absconding accused against whom an inquiry or trial is pending. I'm very grateful, my lord. If I have anything else to say, yes, before I conclude,
But
my
in the
lord,
reference order, there is no mention as to why Hardeep Singh is bad.
there is nothing. So it's only they don't say Hardeep Singh is wrongly decided. Reference order says some clarification.
Further enunciation.
Yes, some, if your lordship will have,
Last paragraph.
yes, para 21 is the one.
Page 3 of the second order.
All right, page 3 of the second.
The order passed by the learned 3 judges.
Correct. On the other hand, having considered
Having considered the matter
at length,
The reference order is why they say it should be considered.
correct. I'll read that also.
Para 23.
Correct. Summoning order passed after pronouncement.
Yes.
Page 2. You know that the judgment.
So, my lord, if I can read first this last para and then para 23. Considered this, I'm now reading that second order. Having considered the matter at length, we are of the view that opinion expressed in Hardeep Singh, which is Constitution Bench judgment, needs further enunciation in the light of circumstances occurring in this case. In this regard, it is appropriate that a Constitution Bench clarifies the same. Now, in para 23, in fact, earlier the court also said that Hardeep did not have an opportunity to cast any light about the validity of summoning order pronounced after passing of it. So that's the part which really the honorable judges thought that your lordship should be seen. Now, my lord,
You read which para?
para 23 of the first reference. Page 13, type at the bottom.
Then it appears that they missed out para 47.
Correct.
Unfortunately, the answers in the last paragraph to question number 1 and 2 are not specific.
Correct.
They
47 is very crystal clear. It is only till judgment, and that is consistently followed. I have attached 2 judgments, one immediately after Hardeep and one as late as in 2021. There are other orders also where it is being followed. In courts, it is being followed. Now, my lord,
insofar as the High Court is concerned, between the judgment of 2 judges and the Constitutional Bench.
correct. That order is on the face of it bad. That cannot be seen.
The High Court
And
is
it reads-
bound by the Constitutional Bench.
Yes. It reads,
And even if para 47 is considered to be an omitter, as far as High Court is concerned, the High Court is bound by it.
correct. 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 Actually, it is the ratio according to me, but in any case, even if it is assumed to be
There is
omitted.
some doubt because of the last
Correct.
answer.
Para 117.
Correct. Para one.
See, what is said in para 47 is not incorporated in
117.
117.
Correct. Now, just one last thing. The solicitor is here in the PMLA case, but if your lordship is not going into the facts of that case, or if he's not going into the facts, because otherwise the facts are very.
Let him say.
I'm not going in the facts, I'm only on law, my lord, as far as.
on these two questions that then I need not go.
Accepting a stay refers to the tax.
Just 1 second. Nagamuthu, you are in favor of what Patwali said, then you can make a submission.
I'm neutral.
You are with him.
I'm neutral.
No, you are not neutral.
Take some side.
I am disappointed, my lord. I thought he
As a neutral man, we are also neutral, but you have to say something.
To some
Mr.
extent.
Nagamuthu would like to go a step further and say that 319 cannot be exercised without noticing the proposed executive.
Brief submission, then we will hear well. We will come this.
Lord, I appear in one of the petitioners, Lord, SLP, and I wish to take some submission. Lord,
Wait, we will hear
after my senior colleague.
We will hear, yes, but it should be very brief.
Very brief and only in addition to
So
what
now
is-
we have understood.
Yes.
Let us.
But I may not take more than 5 to 10. No. But it is agreed not to put this on the report. The Hadith check is very comprehensive enough now to cover all the points under section 390. Now, there are 3 issues not raised. Issue number 1, well, question number 1, you have to kindly consider whether the trial court has power under 319 CRPC for summoning additional accused when the trial with respect to other co-accused has ended and the judgment of the conviction has been rendered on the same date before pronouncing the summoning order. So the question says, well, summoning order came later, acquittal order came first. So after the acquittal of the accused who are already facing trial, whether the summoning order can be issued subsequently when there was no proceeding pending. But this has been answered in Hadith Singh, therefore the question can be very simply answered that Hadith Singh covers it. Hadith Singh says, power under section 319 can be exercised after taking cognizance, not before, and until judgment is pronounced. Hadith Singh says, so here judgment has been pronounced, and after judgment has been pronounced, as per Hadith Singh, no order can be made under section 319. So this can the question can be very simply answered in that way. The question is not whether in this given case the 319 order was passed when the proceeding was pending or after a termination, a question of fact, which cannot be gone into by this order with my humble submission. This is to be gone only by that court where the matter is actually pending. But the question is, there was one question interestingly raised as to when the proceeding gets terminated. The argument is, as soon as the arguments are over, as per section 353, the trial gets terminated. And therefore, if any order is made in section 319, after the arguments are over and before judgment is delivered, that itself is.
No, that is not Mr. Patwali's argument. No.
That is the argument.
No. He says that once the judgment is pronounced, then the court becomes functional official. He also agreed that in the event the evidence is complete, the matter is argued, the judge goes through the papers and before the pronouncement of the judgment, he finds that there is some material against the proposed accused, then at that stage of power can be exercised. Have we understood properly?
Because then the trial will be reopened. Necessarily the trial will be reopened.
In the referral order, yesterday he referred to section 353 to say that the trial is over, the trial is over, the moment arguments are, that was in the referral order also says the same.
Yes.
The referral order also says the same.
The trial is over the moment the matter is kept for orders. When the judge says arguments concluded, judgment reserved, trial is over. That's one part of it. That's the CRPC is clear. Then the observation came. What happens if the trial is over but judgment has not been pronounced, and he finds that there are some people who needs to be arraigned? Is he powerless? My submission is no, he is not powerless.
That's what
He is not powerless because then he can reopen the trial because then it is still within his strength.
once the judgment is pronounced,
Then it is
hands off.
correct. So if the trial is over, but he is still in session because he has power to reopen the trial.
After the trial is over, he examines the evidence,
Correct.
he considers the argument.
Correct.
And at that stage, he finds that no, somebody has to be proceeded further.
Then he will reopen
the trial.
and then pass an order and continue.
That is as a suo motu under 390.
Yes, yes.
He can always, that is an inherent with every judge who is dealing with the case.
In the referral order, you have to kindly see there was an argument advanced that if one case is kept for judgment, then after that there is no power.
But then he has fairly, even now he is.
Now, if you concede, we got no difficulty. If you concede. So this is regarding question number 1. Therefore, Mada, in my written submission, I refer to section 232, 235, also to say that the proceeding get terminated on the pronouncement of judgment. But if it is a case of conviction, not even by the pronouncement of judgment or conviction, until sentence is imposed,
Yes.
because proceeding continues, evidence can be let in respect of the question of sentence. Accused is to be heard. So until Murad sentence is imposed on the accused, proceeding is pending before the set court. That law, Murad, has been laid down by 3-judge bench of this honorable court in 1995, 2 SCC page 513, Ram Naran case, Murad, paragraph 12. They very elaborately dealt with the same. 1995, 2 SCC 513, paragraph 12. So this is on the proposition, Murad, that
Have you ever referred to in this chart that judgment Ram Naran? No.
Ram Naran is not perfect.
What is that judgment?
1995, 2 SCC page 513, paragraph Murad 18, 12, paragraph 12. 12 and 30.
2 SCP.
Page 513. Judgment. That's the point. What me really can do paragraph 12. Paragraph 12 minutes. Page 523. Chapter 18 relates to trial before a court of session. Section 225 to 220 relate to stage prior to the framing of charge. Section 228 provides for a framing of charge against the accused person. If after the charge is framed, the accused pleads guilty, Section 229 provides that the judge shall record a plea and may in his discretion convict him thereon. However, if he does not enter a plea of guilty, Section 230 and 231 provide for needing of prosecution evidence. If on the completion of the prosecution evidence and the examination of the accused, the judge considers that there is no evidence that the accused committed the offence with which he is charged, the judge shall record an order of acquittal. This is 232. Seldom it is used by the trial courts nowadays. 232. When all the witnesses turn hostile, there is no need to put questions under 313 or to call upon the defense to examine any witness. Straight away, the accused can be acquitted. The distinction is this is an order of acquittal, not judgment of acquittal. It's an order. 232. The court shall record an order and simply acquit by writing in one line that there is no evidence. So, if this is 232, you have to make a if on the completion of the prosecution evidence.
Nothing for 313. No, there is nothing for everybody.
There is no incriminating evidence. No giving a benefit of doubt. Simply acquittal. This is by means of an order. The distinction is under section 232, it is an order of acquittal. Whereas under section 235, it is a judgment of acquittal. Judgment should contain all the details as are prescribed in section 353 and onwards. Last title, issue, so many things are prescribed in section 353. You have kindly have. The 354 language and the contents of judgment, except as otherwise expressly provided by this code, every judgment not an order, every judgment referred to in section 353 shall be written in the language of the court, shall contain the point or point for consideration, the decision thereon and reason for decision, shall specify the offence of which and the section of the Indian Penal Code or other law under which the accused is convicted and the punishment to which he is sentenced. If it is to be judgment of acquittal, shall state the offence of which the accused is acquitted and direct that he be set at liberty. When the conviction is under section of the Indian Penal Code and it is doubtful under which of the two, it goes like that. So this provision section 354 is not applicable to section 232. It is an order, it's not a judgment. There is a vast difference between these two. Reverting back to the judgment in Ram Naram, paragraph 12, middle, the accused would have to be called upon to enter if the judge does not record an acquittal under section 232. the accused would have to be called upon to enter on the defense as required by section 233. After the evidence in defense is completed and the argument heard as required by section 234, section 235 requires the judge to give a judgment in the case. If the accused is convicted, subsection 2 of section 235 requires the judge shall, unless he proceeds in accordance with the provisions of section 360, hear the accused on the question of sentence and then pass sentence on him according to law. It will thus be seen that under the code, after the conviction is recorded, section 235(2) inter alia provides that the judge shall hear the accused on the question of sentence and then pass sentence on him according to law. The trial therefore comes to an end only after the sentence is awarded to the convicted person.
Yes.
Perfect.
So therefore, Murad and
Nagamutu, section 232, does it use the word order or judgment?
order,
Order of acquittal.
order of acquittal. Document really have a look at it.
Because a judgment was.
If after taking the evidence for prosecution, examining the accused and hearing the prosecution and the defense on that point, the judge considered that there is no evidence, in that the accused committed the offense, the judge shall record an order of court, not a judgment. Therefore, 353, 354 not applicable. 313 questioning is not there because there is no incriminating evidence. Straight away, not by single line, the court can say that there is no evidence. Therefore, I am recording an order, acquitting him. That is enough.
For how many decades this provision has not been exercised?
In some judgment, in our High Court, we highlighted this. And we also told the judges in the Judicial Academy, but
They're scared,
it is strictly followed.
they're scared to use.
Statements.
But it will reduce the time of the court.
We see some of the convictions recorded only on the basis of 161 statements.
Yes. That is also there.
At least I know of cases where 313 statements are not recorded in the person is expected. There are some cases, at least in Gujarat, where 313 statement is not recorded, where there's nothing to be asked, and they're acquitted. But these 232 provisions are followed in, at least in Gujarat. I don't know about Tamil Nadu, but
It is not followed.
At least in Maharashtra it is not followed.
Followed. Yes.
many cases, there's so many cases, those cases don't come up, my lord.
They are acquitted before 330.
Actually, you can.
If there's no evidence.
Time if we apply all.
Yes, we can save the
Those
time.
cases don't come up to the High
You
Court.
can save time, but you can't save the judicial officer then.
That is also a problem.
So that is what I intended to say, but I thought that it was not appropriate for me to say this before this honorable court.
They are afraid.
But
They are
I
afraid.
take a different view, and they may issue memo calling him upon to explain it why you have not written a judgment. That is why they are afraid. But therefore, I would request this honorable court not to declare that this procedure can be strictly followed. Because statutorily it is permissible for them. They are afraid of reeling. They are afraid of reeling. That's even in respect of the Arnesh court case, you lordship knows more that when there is no material available to remand the accused, but the magistrates still, even today, they remand. They do not want to run the risk as it was pointed out by Honorable CVRSP. They do not want to run the risk. That's a problem. So therefore,
If all of them follow all this, then all of us will be running out of business.
We also will.
as it may be.
We also will.
So therefore, my fervent request would be not, at least in this case, we ought to kindly declare that section 232 may be used in appropriate cases by the courts.
But that is not a point for reference. Again, you will
Yes,
find
yes.
with us.
There may be an case, an observation made by the honorable court.
All right.
So
Yes.
therefore, my humble submission so far.
There is evidence, it is not using it.
Therefore, in a nutshell, the trial comes to an end only upon sentence,
Sentence or acquittal.
acquittal.
Until the trial goes on, until then the court has got power under 319,
Even if it is reserved for judgment, still the presumption is trial is going on.
trial is going on. Because on conviction, the accused is to be heard and the accused has got right to lead evidence. Under 235(2), he has got power, right to lead evidence. So therefore, my humble submission, this has been held by the three judges. Trial gets over, but sentence is important until then.
Even if the judgment is reserved, still there is an opportunity to open the,
Open it.
reopen the case.
Then 311 can be filed by the accused at any stage.
What provision?
311 can be filed at any stage. Like civil case, there is no provision here to reopen at all. In CPC, there is a provision to reopen after the case is reserved for judgment.
Yes.
But in CRPC, there is no such provision enabling the court to reopen. There is no need, necessity. But the accused can very well file an application under section 311 at any stage of the trial before judgment is pronounced. And there is no question of reopening. Question is whether to allow the petition or not.
That's different, that's different.
Yes.
That is on the merits. Of the
Merits. So there is no question of reopening. Yes, 311. Pending. Any court may, at any stage of any inquiry or trial or other proceeding, under this code, summon any person as a witness or examine any person in attendance, do not summon as a witness or recall or re-examine any person already examined. The court shall summon and examine or recall and re-examine any such person which evidence appears to be essential to the just decision of the case. When the matter is under consideration for preparing judgment, the court finds that some important witnesses have been omitted. So motor court can do under 311. There is no question of reopening. The suo motu power of the court in the second part of section 311 gives suo motu power and it compels the court also. So therefore,
So after the judgment is reserved,
yes,
now after going through all the materials, the magistrate may feel he wants to summon somebody.
yes, he can.
311.
He has to. Not only he can, Murad. There is an obligation on his part to summon. Second part. First part, no discretion of 311. So for a second part is concerned, it is obligation, it is necessary. Let me kindly have a look at any court may, first part. At any stage of any inquiry, trial or other proceeding under this code, summon any person as a witness or examine any person in attendance. Do not summon as a witness or recall and re-examine any person already examined. This is the first part. Then second part. And the court shall summon. Second part. The court shall summon and examine or recall and re-examine any such person if his evidence appeared to it to be essential to the just decision of the case. A witness already examined can be recalled. A witness who was not examined can be summoned afresh.
At this stage, he can even issue 319 also. Why not?
Yes, based on that evidence.
Based on that.
Based on that.
Or whatever. Yes.
Based on that evidence. He can summon somebody. He can examine, promote his evidence if he finds that some person has been omitted, who should also be tried along with these people. Then he can be summoned based on that evidence. So therefore, in conclusion, my submission would be that trial gets over the moment judgment of either acquittal or imposing sentence is until then 319 can be.
So you also agree with Mr. Patwalia that once the sentence is imposed,
Yes.
Yes.
319 cannot be invoked.
Yes. Yes, Mother. So it's a question of fact. In the given case, it's a question of fact. Whether sentence was imposed.
So no. The question, one of the questions posed is the same question.
Yes.
Whether after pronouncement of judgment,
After
whether 319 could be invoked or not.
Brother Hardeep Singh itself says that after pronouncement of judgment, the power of 319 is not available.
Typically, that is said in para 47, but not in the concluding paragraph.
Then, Murad, we move on to the second question, Murad. The second question is whether the trial court has power under 319 CRPC for summoning additional accused when the trial in respect of certain other absconding accused whose presence is subsequently secured is ongoing, pending, having been bifurcated from the main trial. But my answer is, it was also argued by him.
It is more an academic, not arising out of the facts of this case, perhaps.
Yes, ma'am. Being academic minutes, the answer would be, my humble submission would be, but the evidence recorded in a particular case is to be taken into account, not in some other case. My lord was also pleased to pose a question to him yesterday, whether such a petition of 319 is filed in a split up case, what will you do?
Yes.
Then he fairly considers that he has to face.
Yes.
So the evidence recorded in a particular case alone can be taken into account, not the evidence either recorded or to be recorded in future can be taken into account.
Yes.
So in this case, Murad, the evidence already recorded.
Except under section 45 or 145 of the Evidence Act. What is that?
That is for the purpose of contradiction. Now, Murad, I will come to the later. Now, Murad, what is the evidence to be considered? Murad, the evidence which has been recorded already in this given case.
What you are suggesting is,
Yes.
in the, let us assume, and there is an absconded, yes, absconding case.
Yes.
In that case, material should come to summon a person under 319.
Yes, in
Fresh
that case.
material. Not
Where-
in this case, concluded case.
This evidence cannot be used in that case, Maharaj.
Yes, you are.
Because under section 273 CRPC, evidence means evidence recorded in the very presence of the accused.
Yes,
Here, Maharaj, the absconding accused is not present here.
yes,
Therefore, the evidence recorded in this case is no evidence in that case.
yes,
In that case, all the witnesses are to be examined afresh in chief examination.
yes.
And cross-examination also. In that case, Maharaj, if it turns out that these people are also involved, based on that evidence, Maharaj, not on the 161 statement, not on the FIR,
Yes,
based on that evidence recorded in that case,
yes.
he can be summoned. Not based on the evidence recorded in some other case.
Even Nagamatu, in reality, all the witnesses must have been fully trained, no? When they go to the second trial.
There is a danger also.
Unless the opposite side wins, you know.
Maharaj, that is why, Maharaj, the evidence recorded already can be used as a previous statement to contradict.
Yes.
It can be used for corroboration. It can be used for contradiction. Maharaj, 145, Maharaj, 157,
Section
Maharaj, is a
145
corroboration.
confronted.
Maharaj, this evidence cannot be previous evidence, Maharaj, cannot be used for corroboration because there are two conditions laid down in section 157. 157 says, Maharaj, any former statement, not previous statement, any former statement given to a person legally competent to investigate. That statement can be used. You not kindly see the language. In order to corroborate the testimony of a witness, any former statement made by such witness related to the same fact, at or about the time when the fact took place, or before any authority legally competent to investigate. Here, Maharaj, the trial court is not investigating. Therefore, the evidence recorded already would not fall under section 157. Therefore, the prosecution cannot use that statement recorded in this case in the future case for any purpose.
Or to the limited extent and on 145 for to contradict.
That is by the accused.
That's all.
That is
By the accused. Yeah.
if he turns hostile by the prosecution. 145 does not put these two conditions.
Yes.
145 is very plain in language. It says any previous statement can be used to contradict the maker when he is examined as a witness in the subsequent proceeding. Here, Maharaj, these statements recorded in the first case are all formal statements which would squarely fall under section 145, which can be used by the accused or the prosecution to only to contradict.
And why do you draw this contradiction only to test the creditworthiness of that fellow?
Yes, yes.
For a limited extent.
Yes.
Whether that fellow is dependable or not.
Section 155, Maharaj. Section 155, how to impeach the credibility of a witness. One of the ways Maharaj used to prove by proving the former contradictory statement. 155.
That's a contradiction.
Impeaching credit of a particular witness. The credit of a witness may be impeached in the following ways by the adverse party or with the consent of the court by the party who calls him. By proof of former statements inconsistent with any part of his evidence which is liable to be contradicted. So I am contradicting under 145. I prove the contradictory earlier statement. Therefore, the credibility of the witness is impeached under section 155. For that purpose, the accused can use it, not for any other purpose.
Only if he resiles from that.
No, but that.
If he's saying something contradictory to what he has said in the
Yes.
earlier trial.
140. I need not go to it, it will take some more time. How to contradict, I need not go into that part in this.
That's all right, that record, you know.
I'm not
You
going
know
to.
that.
There are two parts in section
Yes.
145.
Those who have practiced in the trial court know all these things. Not directly who come to Supreme Court.
Don't consider this, right? Court laid out the law.
35 years of experience in the trial court.
Yes.
Little I know. I'm sorry.
No, in this case, already an application has been filed and this order has been passed, which is a subject matter now. Now there is another trial which is going on.
No, not.
Now, in that trial, if the evidence comes up, is there a bar to file a similar application?
Similar application can be filed there.
Can be filed,
That is a different evidence.
provided that evidence comes, that evidence,
It can be.
Evidence should come afresh.
I agree with that.
it can,
It can be.
so that can,
Somewhat that is in respect of second question. But third question,
Mr. Nagamutu remembers all my concessions very clearly.
Patwalia, trial court practice should be made mandatory for all the lawyers, not very directly government coming here. And taking some interim order and walking away.
honorable judges have the rich trial experience. Sitting in this bench, one of the honorable judges I know has got rich trial side experience, but on the civil side.
But trial side does not get you money. That is why we land up here.
Yes, my lord. My lord, regarding third question, my lord, both the sides my lord, said that Hardeep Singh is very comprehensive and therefore further guidelines are not required.
Yeah.
My lord, at least on two issues, my lord, there may be some addition. Number one, my lord, question is, Shashikant Singh case, my lord, we say, question also arose yesterday. Suppose the accused is added, trial is pending, 100 witnesses have already been examined. Now at that stage, my lord, one accused is added on section 319. Now whether de novo trial is to be conducted in respect of all the accused, in which case the evidence already recorded will not be, cannot be considered. Fresh evidence is to be recorded. Those 100 witnesses are to be examined afresh. It will be laborious. It will be unfair, my lord, so far as the existing accused are concerned. To ask them to face the trial again, to cross-examine the witness again, all these things. So, but practically, what is happening in this country? But whenever an accused is added, he is tried jointly, necessarily and compulsorily with the existing accused. That is why this problem arose. Yesterday, my lord was also pleased to ask me what will happen to the earlier evidence. The section 319 says that de novo trial so far that person is concerned.
Such persons.
Which means not the newly added person. Therefore, my senior friend was referring to section 317, we say that you can split up the case. 370, with great respect, 317 won't come at this stage at all. What is the relevant provision of 223? You have to kindly consider 223.
Yes, 223.
What person may be jointly, may be charged jointly? The following person may be charged and tried together. Not my kindly consider. Charged and tried together. Namely, persons accused of same offence committed in the course of the same transaction, persons accused of an offence and persons accused of abatement or attempt to commit such offence, persons accused of more than one offence of the same kind within the meaning of section 219, then formula D. Persons accused of different offences committed in the course of the same transaction. But the court has got discretion to have a joint trial of all these accused who fall under any one of these categories. But it is not mandatory that there has to be a joint trial in every case. It is a discretion of the court. For the sake of convenience, this discretion is used to have joint trial in every case. The accused has got no right to demand for a joint trial in any case. It is a discretion of the court. Suppose, under section 319, one accused is added. The court has to, at that stage, decide whether he should be tried jointly as per this provision along with the rest of the accused or not. He has to decide. If he decides, yes, it is better that he be tried jointly along with other accused, then, my lord, this problem will arise. All the witnesses are to be examined afresh. Suppose the learned judge decides, no, it is not necessary. He can be tried separately as per section 223. He will be tried separately because 223 is an exception to section 218.
to 370.
Yes, I will come to that point. Therefore, under this provision, at that stage, court has to decide whether to have a joint trial or separate trial. The court decides whether to have separate trial, then my lords, de novo trial. First trial will begin only against this person who is under section 319, not against all. So ultimately, my lord, there will be two trials. One against one set of people, the other against the newly added person. Two trials will be there. In the former case, there can be a judgment delivered separately, and in the subsequent case, my lord, because after 319, charges are to be framed against him, evidence is to be recorded. The evidence already recorded in the earlier case is no evidence in this case. Because under 273, you ought to kindly have a look at section 273, my lord.
But we see 3191, it says, could be tried together with the accused.
Who could be tried together,
Ah,
not to be tried, could be tried, who could be tried together, and he may be tried separately also. Language used to be not make kindly.
Nagamutu, tell us one situation.
Yes.
Now take a case where before the judgment is pronounced, an application is made either suo moto
Yes.
or at the instance of somebody.
Yes.
Before the pronouncement of the judgment.
Yes.
Now trial is complete.
Yes.
Now what should he do? The magistrate has.
Now 319 used to be allowed.
Ah.
On allowing that, he has to pass an order directing separate trial against that person alone.
Now till the trial is completed, the judgment has to await, is it? The other judgment?
Until 319 order is passed, he has to wait for without pronouncing judgment.
No, 319 order not, after a trial on a, against this person, then simultaneously judgment.
No, not necessary. Because separate evidence, fresh evidence is going to be recorded in the subsequent case.
Yes.
It is only on analyzing the evidence to be recorded in the fresh case, the new case,
Yes.
judgment can be given.
But in the meantime, can he pronounce this judgment?
Yes, there is no bar.
But then Patwale has no case then.
There can't be. The reason is this, you will not be kindly consider. There are 10 accused in a given case. 2 people are absconding. 8 people are tried. The case against 2 people are separately kept. They are split up, separately kept. Can we wait for the trial of those 2 cases to get completed without pronouncing judgment of first case? First case judgment can be pronounced. The second case will begin later. Trial will go on and there will be separation. But only one thing is, the same judge cannot try. Because he has already made up his mind. He cannot try. The case has to go before some other judge. He will try the case. That's the only thing. So, my humble submission would be, under 223, the court has to decide whether to have a joint trial at that stage. If the court decides not to have a joint trial, there will be a fresh trial against the newly added accused. Insofar as others are concerned, judgment can be pronounced based on that.
Allowed earlier.
Yes,
Correct.
earlier.
It doesn't go against Patwali.
Yes,
Doesn't go
that
against
is a
the
question.
application should-
That is why I did not go into that, whether the order was passed before pronouncement or
No,
after.
that is inherently allowed.
It's a question of fact.
Then say that it will be a separate trial and then pronounce the judgment.
319 used to be allowed when the trial is pending. At that stage, when the accused has to be summoned, he will appear. The court has to comply with section 207, supply the copies, and thereafter, court has to frame charge, whether jointly or separately. At that stage, court has to decide. It is only after compliance of 207. All these things must happen when the trial is pending. When the trial is pending, 319 is to be filed. When the trial is pending, 319 is to be allowed. When the trial is pending, accused is to be summoned. When the trial is pending, copy is to be furnished to him under 207. Then at that stage, what's enough framing charge comes under 223. Under 223, at that stage, what has to decide?
but in this
What
case,
has to decide whether he should be jointly charged or separately charged? 223.
Muthu, please come at 2. We have to raise a bit early.
Grateful.
But we may have to ask you a few questions.
Grateful. Grateful.
What he's saying actually supports me. That it says this order has to be.
You are right. Because the application has to be allowed first.
First, that is-
Thereafter, he can, because he is right, independent evidence has to be let in so far as that accused is.
Thereafter, he decides whether he wants to have a joint trial or a separate trial.
Yeah, you are right. You are right.
in this case, but in this case, all that happened on the same date.
Yes, sir. That is.
After the judgment was
That is on question of fact, that is put decided by the other court, not by the Supreme Court.
Nagamuthu, supposing an application is allowed before pronouncement of the judgment, let us
Yes.
assume,
Yes.
then he has the discretion to scrap the entire evidence and try together or he can independently try this person.
Yes, it is for the judge to decide.
No, he has the option, this or that, depending on the facts of the case.
No, option is for the court, not for the accused.
Yes, yes.
Court, for the court. Accused cannot demand, Murad, that I should be tried with this man or I should be tried with the other man.
This is what is happening every day. They say transfer this case from this and
Cannot make a demand.
even the CBI says don't transfer.
No,
this
the
case.
proviso to 223, it gives a, he can make a request and court may consider even in cases which are not connected.
Yes, accused has to make.
Even the accused
make a
can-
request,
Proviso.
but he cannot make a demand.
You can't.
He can only make a request. That is, Murad, in respect of some other case also, he can make a demand. He make a request. Suppose, Murad, I am an accused in 3 theft cases. Only one case is pending before this court. I can request the court, Murad, to bring those 2 cases here. Because we join trial. That is permissible under section 223. That need not be there. It need not be that all the offences are in the same transaction. 3 different transactions, 3 theft. Today one, tomorrow one, day after tomorrow. 3 different occurrences. But still they can be tried together. That is dealt with in section 221, Murad.
It should be in 1 year.
221.
It should be in 1 year.
So the accused has got right only to make a request. Please try all together. That is the only request he can make. But it is the discretion of the court whether to allow or not.
We will come back. Huh?
Great. So good.